selling the order of the single bench.
Make use of mic. Be loud. Your voice should be
Selling the
addressing.
selling the order of the honorable. The reason for assailing the order is.
Do you want to argue the matter?
No.
One date.
Date means tomorrow.
Well, when? Tomorrow only.
Tomorrow, because contempt has already been filed. Tomorrow.
One matter. Not come. The husband has already married. It is an urgent matter. Can I press any other dates which will not?
Yes, sir. Yes, sir. We'll have it in the post 21st. After 21st.
All right, obliged.
May I take your lordship kind permission to make a mention for
Yes,
an urgent
yes,
matter for listing Miller
Listing, when do you want?
relating on tomorrow Miller relating to the petition.
Admission last date is what?
Last day is Supreme Court that dictum Miller 15 August.
15 August.
Now counseling is going on Miller. Our institution, the petition institution, is an existing engineering college. In spite of the AICT approval in respect of the increased intake Miller, the OJ is not adding.
No argument. Not necessary. Victor will take it tomorrow.
Oblige Miller. Lordship Miller.
Lords, I may be pardoned, my lords. I'm on BC, my lord.
Page 3, 11 to 17.
Nobody. There is nobody.
Lord, item number 14.
15.
Lord, item number 14, Lord.
14.
Yes, last week it was there. The Lordship was directed to obtain instruction as to what would be the amount, like the quantum of that dismissal.
We will pass a order, sir. This can't be done. We will pull out a file and start it.
We'll consider it. When it reaches, we'll consider.
My lord, item number 2, my lord. Item number 2.
Not 2.
Yes, my lord.
One has got.
1 second. In a couple of seconds, we'll reach to 2. Yes.
Item 1.
My lord, I may be pardoned to make a mention.
We'll solve this matter after half an hour.
Also look at the court brief because you might not be aware.
And interestingly, I mean, the opposite party is yet to be noticed, but they have filed a memo. I don't know on what basis. So I'm just praying for a short adjournment so that I'll seek instruction whether they have implied, whether they have complied with. They want to pursue with this review application, my lord.
In state of Orissa, my lord, initially there was an
Let me come to the prayer.
What is the prayer? What is your prayer?
now in the mid of this counseling, which has
I'm
been
asking you.
My lord.
What is the prayer?
was the
Page number.
my lord, that I have prayed to pass the revised my lord,
This letter to be questioned. Why?
because my lord,
How you are affected?
my lord,
What you are? What you? I mean,
I am an applicant
to do
I am an applicant who applied pursuant to the
Same question.
for PG council for
PG, my lord.
PG.
And my name, our name has been included in the merit list.
Included.
My lord. Now what has happened, my lord? They are trying to reopen it to accommodate some.
Have they reopened?
My lord, that is what is under challenge.
That letter itself is reopened.
My lord.
Which letter it is?
How do you show that?
Party 3.
Now the question is, Lordship is asking you how to go before the court that you are adversely impacted because it's just possible that your rank will go up.
My lord. No,
Because in the counseling process.
my lord.
Have you ever seen any counseling process? You have to see to understand.
My lord, what exactly has happened? Initially,
No, please don't explain. What is your grievance that you are adversely impacted?
my lord, this revised schedule is against their own guideline and against the
The question is simple.
my lord, there is every chance that someone would come in.
So how can we say that there is a possibility?
In the
or-
event it happens, you can.
No, my lord,
Chance cannot be.
what I challenge is that
Litigation is.
my lord, in the instance of one or two people, the process of selection cannot be molded or revised in an instance of one. And my allegation is that they have 1-2 people for which they are reopening the process.
Assume it is true.
Alleging a mala fide in a computerized process,
My lord,
it becomes impossible for a court to say that strike it down.
no, my lord,
See, it is all your assumption and presumption, and maybe a gut feeling.
no, what?
So,
You don't want to process what we are saying.
No, my lord,
Instantaneously, like a child is not wanting.
my lord,
Process what we are saying.
my lord.
Hold
Sorry,
back.
Sorry, my lord.
Process.
Aye.
Then come back with answer. That's
Sorry, my lord.
We are asking you.
My lord.
We are asking you how you will be affected by this. It is only a chance factor. Can chance be a cause of action?
Well, in addition to that, what I challenge is that this process, suppose again someone will come up and then and this
Then
schedule,
cause of action.
well, this schedule is going against the schedule fixed by the NMC, and there is every chance
sir,
that will be trouble.
unless it is very simple, sir. Whatever your clients are telling, you have not asked. You should have asked these questions to them before arguing before the court.
Man,
Because interfering with a counseling process and that too for PG dental
man,
has a serious consequences.
man,
And in fact, you have argued fairly that Supreme Court has set a guideline.
man,
Suppose they falter in adhering to their timeline, not guideline, timeline.
timeline.
What would be that? No. He should be aggrieved.
He should be agreed.
There may be a violation
Man,
unless you are aggrieved by that.
man,
That
I got right.
Therefore, what we suggest is we will dispose of this matter
with liberty to argue.
to come for the court in the event you get any injury, legal injury.
Man,
Petitioner, an aspirant for a particular seat in the dental branch of knowledge is in PG, in dental branch is grieving before this court, and he has scripted the prayer column as under prayer column. Next one. Learned panel counsel on request appearing for the respondent.
yes, sir. PG counsel
Opposes the petition 213, contending that the petition is premature and that there is no coherent cause of action in as much as there is no denial of seat as yet to the petitioner. First one.
Choice also. You have seat oblique choice because
Subject seat stroke
choice of substance.
Sorry. He also tells that the cause of action in the petition is incoherent, INCHOATE, incoherent, and therefore no interference of this court is called. We agree with this. Next, in view of the above, petition is disposed of, reserving liberty to the petitioner to come before the court in the event a coherent cause of action arises by virtue of legal injury. First, ordered accordingly, and the petition is disposed of. Yes.
Deeply please.
Next point.
Item 9.
9 Millard.
Let's go say mandatory functions of law violation.
Still,
You cannot compute.
But this sole responsibility. The petition filed for confidential delay. So I objection to that. You also can't.
Well, notice was ordered already.
Notice has been prior
Notice has
to
been sent on
before condemnation of
19/4.
delay. Interim order has been passed, man.
Before condoning delay, interim order is passed.
Yes, man. So I may be permitted to file objection to that.
because of the content. Why? The interim order regarding what?
Millard,
No,
dated
content was not-
19/4/2023. Millard.
There is content proceeding now.
Since 23, the interim order is there.
You can argue on the main matter itself.
My lord, that matter, work charge employees, which is pending, my lord. This is on job contract and the work 18.3 and 18.6, my lord. So I think if at all it will be.
Similar matters we have already. And we'll have all those matters on one particular day.
My lord, today I am giving the details. What are the matters which is covered under the work charge today in lunch hour?
Very good. Very good.
All 500.
No, all 500.
So then
matter which
then
is
what is the point, sir? You see, you are the SLP, you are the appellant.
Yes.
You know how many SLPs you have filed. So convert that into the writ petition because it has
that I am doing, my lord. But fact remains, there are 6 to 7 writ applications in a particular writ application. Now I am in the process, my lord. But the matter which
When
was
we should call this man?
4 weeks after.
4 weeks.
Because in the meantime,
4 weeks.
2 weeks. 2 weeks we'll give you. 2 weeks we'll give you. Then let us see what should be done. Call this matter.
To assign someone, this is only to assist you. To assign someone in your
I have done it. Half of the way.
SLP, how many have been remanded?
How many have the writ
Because that will help us also. We have asked the registry anyway.
No, we have also in the process, sir, to assist you also.
Call after 2 weeks at the request
But
of.
this has not gone to Supreme Court and travel back.
This is in respect of that Naresh Pradhan, madam.
That was followed.
That is in Nityananda Vishwa. This is in Naresh Pradhan.
Nityananda and Sudhanshu.
Two Nityanandas.
One is Nityananda Das and one is Nityananda Vishwa. But everything has been taken care of in this Sudhanshu case.
In Apex Court.
Exactly.
Item 10.
Item 10, my lord, notice to be made sufficient because so far the OP number is.
You are appearing. I have the instruction to appear for the respondent, sole respondent, my lord.
Are you ready in the matter?
I have not copies. I have not received copies.
You are not ready. You said copies.
So I'll file my vakalat.
You received the copy because it has returned answer. You
Well,
receive here in the court.
In the court of let's say, do you have a copy of that one here? Yes. Papers. You copy to no. Petition copy.
It has been written because of the address left, the remarks.
No, anyway, now.
My lord.
No, he says that yes.
You want to file power?
Yes, my lord.
Sri so and so submits that. He represents the respondent and he would be filing the power within 2 weeks.
Within 2 weeks.
Within 2 weeks. First. Registry to print the name of the council. Call this one.
My lord, may so respondent number 1.
Respondent number 1.
Yes, my lord.
The noted counsel for the respondent was instructions to appear has the liberty to receive the unserved notice along with the copy of the writ appeal in the court itself. To be countersigned by the court master.
Yes.
Item 11.
There is 271 days delay in filing the appeal.
71 days. We'll conduct it. Less than 100 days. We'll extend the same facility to you.
Yes.
Application supported by affidavit seeks condonation of delay of 71 days.
No, Bruce. 271.
271 days to filing the appeal. If it is 271, then you have to give him one small book. Which book will give?
Lordship petition.
Right. A plausible explanation is offered for the delay proof. First, this apart Apex Court in a category of decisions has held that while considering delay application filed by the government and public authorities, courts have to be a bit lenient ordinarily. First, next one. In the above circumstances, application is allowed and said delay is condoned, subject to the condition that the appellant shall present 2 books by Paulo Coelho, Alchemist by Paulo Coelho, to the bar library.
Alchemist.
The bar library, Alchemist. One of the famous books. It is printed more than Bible. That for the read that book also. That I do not know whether it is available in Orissa or Oriya language.
Oriya language.
I don't know. One of the last night of I sat on the bank of Vidra River and wept. Who will cry when you die? Oh, many wonderful books here. Yes.
In this case, no admission has been made. Let me hear this matter.
For admission itself.
Yes, madam. Because
Any merits in the matter?
Merit is there.
I think there is no merit. So for that reason, I consider to that condemnation of delay.
Okay. Can we have it after 2 weeks? So that
Sorry, because I am out of employment. That is my.
You are without employment how long?
Since 2018, my lord.
18.
My lord.
So last 7 years you are without.
That
So we will have this after
for 7 days, my lord. Your lordship.
7 days. Next week. Because he considered that delay. The impression that we will hear this matter.
Yes, ma'am. That's why I.
Next week we will.
My lord.
Not yes.
One aspect is there, my lord, the person who has suffered the judgment, my lord, he is affected. He is not turning up before your lordship, my lord. That is one.
So he has refused. Arthur has refused and
Yes.
this has been made sufficient.
He is refused.
Sufficient also. Okay.
And about 3, what is the discussion regarding 3 we served?
Regarding 3, notice is sufficient. my lord?
Notice is sufficient.
Notice sufficient. Both are sufficient.
Because
After 7 days, my lord.
in that judgment,
Next week we will have.
Next week.
Okay.
Item 12.
Yes. Sir. Well,
Time for the opposite.
you are for opponent. Who appears for the appellant?
Are should be Passover or Raja?
As your lordship pleases.
Since none appears for the appellant.
On the last occasion, they have taken time
Again.
to comply with them.
For complaints.
Compliance.
No, they have taken time.
They are taken time. None appears for the appellant. First week of August, second week of August 2025. And to enable counsel for the appellant to comment, we have noted the presence of learned senior advocate Shri So appearing for the caveat respondent. You appear for the
Yes, I am on caveat.
caveat respondent. Okay.
Probably a second appeal as I was.
That Anganwadi worker matter, wherein the appeal to the ADM and newly added provision that second appeal is there to the artist.
Also whether
Let him come and
Let the petitioner.
Because we have held one judgment we have held already,
Exactly.
which we agreed with you.
Yes, sir.
Do you have copy of that judgment?
No, my lord, I have not got it. I will collect it. my lord.
Place that copy.
Aye.
Yes. Great. Yeah.
Item 13.
And 13, my lord, here is a delay, my lord. It is of 52 days.
All right. On merits, what you have got? We have to see the merits also while considering application for continuation of delay. 86 Supreme Court. Tell what is on merits.
Lord, I searched for time because lastly I have received this brief.
You want time?
Tomorrow, day after tomorrow, or Monday it may be.
Next 2 weeks. 2 weeks we'll have to call up to 2 weeks at the request of the state council for the appellate. Yes, next.
Item 14.
May I please, Your Lordship?
Yes.
Your Lordship, on last occasion, Your Lordship had asked for a chart that how much salary.
he's seeking instruction on that. If you exchange that amount, we have suggested for
I have
in the beginning.
I have seeks little bit of instruction from my client, Your Lordship.
Not yet.
Yes, I have got
Received?
it. Yes, Your Lordship.
What are your
Yes, I have made a small note,
Yes.
Your Lordship.
Please share that note.
Yes.
And with us and with the learned.
Just now is
You have got it.
just now is
I've only
This 11 lakhs 27,000.
That is only, Your Lordship, that is only regarding to the salary, Your Lordship. I have not calculated
You
any.
don't expect the full salary because you are not granting it.
No, I'm not.
Because you are expecting reinstatement with full back wages.
No, Your Lordship.
If you remember the last,
Yes.
you were present.
Yes,
So,
Your Lordship.
So Patnaik argued, but you were present.
Yes, sir. I have given the office order, Your Lordship. Office order and the first one, Your Lordship, from 1/4, that is 2000 to the first till 5 to 9, whatever it is written in FP, those are the salaries which is.
You have received now.
Just now I received it.
You want to consult your
I
client?
will get instruction on this. So let's call it on 18th.
Call on 18. At the request of learned counsel appearing for respondent, final counsel appearing for respondent, to have conference with his client and come back on the memo filed by learned counsel appearing for the petitioner. Memo filed by the petitioner along with calculations, calculation sheet is taken on that one.
Oblige, Your Lordship.
On 18th, Your Lordship.
18th.
Oblige, Your Lordship.
Next.
18.
Yes.
There is a delay of 24 days.
Will condone delay?
Look, I have filed a small objection. Now, I wouldn't normally come in the Your Lordship's way to condone the delay. Kindly see the delay application.
24 days. Your objection, sir?
Lord, my objections, preliminary objections are filed to the IA number 6946 of 2024.
So Das, you sit down and catch your breath.
Thank you. Thank you.
My lord is always asking that all of this person to appointment to.
I realize how unfit I have become.
Can we pass over for 10 minutes?
I'm obliged.
After 1-2 matters, we'll call you again. Yes.
Item 16.
May I please, Your Lordship? Well, in this appeal, my lord, there is a delay of more than 1200 days, my lord.
1200 days.
Yes, my lord.
What is the explanation?
Explanation, my lord. The previous conducting counsel, my lord, did not inform the client about the dismissal of the writ petition. And my lord, there is a delay in COVID also. COVID period was going on.
When dismissal took place?
9/1/2020, my lord.
9/1/2020.
Yes, my lord.
9/1/2020. 25/3/2020 is COVID declaration.
Yes, my lord.
25/3/2020. That was up to COVID was in operation. COVID, the Mass Disaster Management Act, which is that notification. Up to what period COVID was in operation? Notification was in operation. There are 2 judgments of the apex court. Do you have them brought them?
March 2022, my lord.
March
2022. The first page was February 2021.
March 20.
Then the second one is.
You are right. It appears it's 15 March 22. Well, where are 2 judgments of the apex court? There are a series of judgments.
Yes, my lord.
2 judgments come to your rescue. Where have you brought the judgments?
I'm extremely sorry, my lord.
Call this matter after 4 weeks to enable counsel for the appellant to come with more preparation.
And Lordship may kindly have a glance to the impugned judgment where there is absolutely no merit.
Why you are hanging? He is an youngster. He has come to court without any toolkit.
Okay.
This we are against. This we are now don't want to write anything because it may affect his career. Therefore, you go to library now. Go and sit in the library. Don't roam in the city. Yes. Yes, sir.
Here in this case, the petitioner filed a IA for modification. This is the case regarding the recruitment of Sipahi Constable into 2024. And petitioner have approached this honorable court in the writ application.
This is 17.
17.
17 is there. You are for the respondent.
Yes.
Yes.
I have filed for modification. IA for modification.
IA says what?
In the writ appeal disposed of.
Yes. That disposed of writ appeal. My lord is a party to the same that.
Yes.
Sipahi and constable.
Because the petitioners along with
3 years has been relaxed for a particular and it is a consensual order. kindly have a glance to that order.
May I place the fact, little bit fact, so that...
We'll see the order. We'll come back to you.
Okay.
It is, to the IA, it is page 45.
IA 45.
To the IA.
Page 45 in IA.
So it is in the judgment itself. Top to Jantu. You practice correlation. Put down to top, judgment to Jantu. Go to the top. Are you proved? अरे अपना डेट
Yes, IA, we have annexed the judgment.
And learned friend has also annexed.
Annexed.
Yes, ma'am. The person, those who have come under within that purview of 3 years, this has been relaxed. Subsequently, when it is attained its finality, then they came up in the IA. It is amounts to rewrite of the same once again.
Yes. Let me place the facts. Initially, the petitioners along with others filed a writ application claiming age relaxation in view of the last examination took place in 2018. Thereafter, COVID was there. And the Honorable Single Judge, after 18 there was no examination. The examination took place in 2024. Yes. Thereafter, COVID was there. 18, there is a gap of 6 years in COVID. Because of that, Honorable Single Judge, relying on the Supreme Court judgment Devina Sharma, given a one-time age relaxation of 6 years. 6 years. Because the examination could not took place from 18 to 24 and COVID. This is 6 years. So one-time measure, as a one-time measure, in view of the Devina Sharma judgment, relying on the Supreme Court judgment, the Honorable Single Judge granted 6 years. Yes, it is there, but I have not brought it. Tomorrow, if I will bring every judgment, Devina Sharma, that Delhi has, it is reflected in the judgment. Yes, I should have. Yes, I should have. Tomorrow I will bring. It will not. May I pray short day?
And the copies be served. So for the IA, one copy they are served. So for the other analogous, by that I can have the objection.
My lord, because they are going to finalize this election. After lunch, then I will place it.
After 2 weeks. You are finalizing everything now.
Yes.
But suppose
the person for the same, the person those who are coming under the purview of the 3.
No, not that. Suppose we are having this matter after 2 weeks. And in the meanwhile, if you finalize everything, where he should go?
It has been finalized.
Finalized also?
Yes, they have given a chance also. Can I have a glance to answer 5 for a moment?
No, they have not finalized. No joining order has not been given. And
call after 2 weeks. If you wait, call this matter on some day.
25.
To enable counsel appearing for the applicant to come with the rulings on which he wants to bank upon.
May I pray the date, maybe fixed date?
Yes.
Date.
Only one suggestion to you. Because Devina Sharma has been considered and noted by the judge bench.
Then only this judgment is rendered.
Then the writ appeal has been, so scope of Devina Sharma has been very well discussed. Because there is a, so many decisions against you that it can't be done.
Because it's a consensual order.
And government has taken the
So government
chance at three.
What is my short prayer, man?
and
Here
3
the
years.
petitioner is in number 4.
3 years because
The petitioner participated in the recruitment process. And as per the interim order,
Anyway, we are posting it, but you can reserve your arguments for that.
any selection subject to result of this the IA.
It's a IA in dispose of writ of
Yes,
my lord.
yes,
you were appearing for some candidates who were also got successful.
Yes.
So please be careful also.
They may,
No,
their
that is
apple
disposal.
card should be-
That is
No, no,
disposal.
anyway, their apple card should not be affected.
Yes, yes.
You got it. You win some, you lose some. So have to. Yeah.
Item.
Condonation of delay.
1-4. Item 1-4.
Item 1-5.
1-5.
120.
Go to IIs.
6946.
Flag D. And my reply is at flag D.
One second. We'll see the IA, how it is structured. Judgment was rendered on which day?
Judgment was passed.
Hearing was made on 8/5/2024.
No.
Judgment was 31/7/2024.
2024.
When did you apply for the copy?
We applied, certified copy was 22/8. Supplied on 27/8.
But when you applied, appeal period had not yet expired. So you filed the appeal on which day?
23/9.
And your limitation period would expired on
30th August.
30. No, okay.
From the date of order.
Appeal is 30 days. And if 31st, so from one day has to be excluded under the General Causes Act.
Yes.
So that will be 30th of September. Minus 7 days. Plus 7 days.
23rd.
Plus 7 days. So that will be
24/8 they have calculated.
24 days.
24/8. Appeal to petition is 13 days. Plus the period taken for preparation of the copy, because copies are applied within the list. All right. To come and collect on which date? Is there such a column in the?
Yes.
When he was asked to come, they may keep it ready, but they should tell him the date on which date he should come and collect it.
Actually, they notified on the same date. So 23rd itself.
Come and collect.
I mean, it's not circulated, it's kept in that bunch.
How you will know?
That usually says that
Because there are Justice Dhawan, our Rajiv Dhawan's father has written one of the finest judgments.
From the Allahabad High Court.
Allahabad High Court. If he gives everything in the registry should inform him. You have applied, you come on
page 23 readable.
Then the limitation begins. Otherwise not. There is no limitation. There is no delay.
Dear my lord, I think they notify it on the site of the High Court that the copy is ready.
Nowadays, it is
Nowadays, yes, it's coming on the site.
It's on the website.
On the website.
This is the
That copy is ready.
make it 60%. Keep it there. It's good.
Is it ready on 27/8? Supplied on 27/8?
No. Ready on 23rd.
23rd.
Supply also 23rd.
Supply
Supply
20, you applied on
Supplied on 27/8.
So means you went and collected it. No, it was notified on website when? Have you taken up that contention in your objection statement?
No,
You have not. Right.
I am simply going on the basis that explain the delay is not explained.
Appeal is filed after looking a short delay of so many days. First off, the delay is too short and plausible explanation is offered for the same. First off, that apart, on such a short delay, if application is to be rejected, that would tantamount to rejecting the bill itself, which courts of justice cannot afford to do. First off, no prejudice would be caused by condoning this short delay. First, next, in view of the application supported by the affidavit having been favored, the delay is condoned. Yes, on merits. Yes. Next. Then you can write third one, three. So it's points. Yes. On merits, are you ready?
Next week, any day.
Call in the first week of August 2025. On request.
Lordship may say reply if any in the meantime.
It is appeal.
Appeal.
What reply?
Very well.
No reply. Yes.
Obliged. First week August, Lordship.
Yes.
Item 80.
Yes, sir.
I don't know. The petitioner is an ST candidate who are appearing the selection process of typist in the office of the district judge Cuttack. He has qualified the written examination. Thereafter, he has called for the computer test. In computer test, he has appeared, but his name has not been selected to viva voxel test.
Why not selected?
That's why I come. When the petitioner does not want the regions, thereafter he applied under RTA Act. What is the region behind it? The evaluation paper sheet.
What is that? Last two sentences repeat.
The petitioner when
he applied through RTA Act,
minor.
He has been given the regions.
Regions.
Sector 4 at page 36.
Minor. RTA Act. We have applied.
Am I correct?
Yes, ma'am.
That you should say.
On RTA Act, they have supplied this evaluation answer script. So,
Give us a number. We're looking at.
Answer proof.
Whether that right to information corresponds.
Your query in serial number 2 in RTA application.
Serial number 2 RTA application, the evaluation answer script and the cutoff mark, my lord. Cutoff mark was 40 in annexure 5.
So then what did you ask for? You know it yourself?
No. They have supplied me.
Ask this question looking at the page 36 when they deny you the information in R2. Serial number 2.
We have sought for the answer script of other students. They have not supplied. Thereafter, from the information they have not supplied the evaluation of answer.
Case. This is exact case. You have secured higher than the last qualified ST candidate or any general candidate?
No, I come to that. One of the answer script has not been evaluated.
Not evaluated at all?
Not even evaluated.
Which is that?
On annexure 6. My lord.
Not you.
Well,
the fact is different, my lord. Lordship, he had approached earlier, Lordship, directed that to make a representation. That representation was considered and it was decided in annexure.
No, he is saying, my answer sheet has not been valued at all. If he shows that is not, he will have a case.
Annexure A/1, your lordship.
Yes. We write answers to garner marks.
Yes.
If you do not evaluate at all, I will not get any mark.
Why it was not evaluated? We have given the
What is that?
annexure A/2.
Do you agree that it was not evaluated?
No, because beyond the time, yes,
are asking you.
Yes, yes. It was not evaluated, given the reason that the invigilator has given the report that beyond the time he scripted his answer script. So there was
After the period is over.
Yes.
Examination period.
Yes. Okay. That annexure A/2, lots of people can have a glance.
So that is time-bound examination.
Time bound.
67.
66. Annexure 10, our counter affidavit.
You were right to evaluation. It is there. But you have to write the answer before the 5 p.m. is.
This is the plea. When I have filed the RTA appeal, in appeal, the appellate authority has directed to supply the answer sheet. Thereafter, we know that I have received obtained 36 marks. The cutoff mark is 40.
Yes. That's all right. But you have
coming to bed. The plea taken by the selection committee is wrong because after the time period over, no one can permitted to sit in the hall. It is a computer-based test. Computer online
glance. That the report.
Let me submit fast, my lord. After the time over, the computer has been stopped. The line has been cut. Though there is no
hard copy one, you are missing hard copy. The word is very specific. Hard copy, you have answered beyond time.
There is no hard copy, my lord. When computer, we have to answer. Thereafter, the print, they have received the print. One, my lord.
So kindly, so you are asserting that. Have you denied that in filing rejoinder that hard copy
is not there at all?
Because this is a read petition.
Earlier, I have
Bharat Singh.
Earlier, I have represented.
Bharat Singh is the standard as how the.
So I will file rejoinder because earlier I have
not by not being. Am I assisting you? That's it.
No, my lord.
So because you say that there is no hard copy, concept of hard copy.
My lord.
So because that the
annexure 6, annexure the earlier writ application, I have filed.
How do you answer para 3 in A/2?
I'll file rejoinder. Give me some time, so I'll file rejoinder because there is no hard copy provision is there. Only computer test.
So kindly read para 3. Then you can also assist the court and ask your client.
Man.
Because interfering in a competitive examinations has its own limits of judicial reviews there. You answered 4 and 5 beyond stipulated time, which was saved in a separate file. So, kindly, if you don't read, you can't understand. Are you tech savvy, computer savvy? Can you understand what they are saying?
Their counter, man.
Not counter.
Do you have elementary general knowledge of computer? I do not have. Therefore, I am.
Man.
If you ask that question to me, I will confess that I do not know how to operate.
The provision is that what I instruct in my instruction.
My brother asked you.
I
read that paragraph.
Paragraph only.
Don't want to read
also. You are going on a commentary actually.
Please read. Let us see what the paragraph says.
Paragraph 5 counterman.
3 sir of page 67.
Paragraph 3.
Internal page 10. Annexure A/2.
There's no document. There's no document.
You look at the paperless.
But they have not supplied the document. Only the
supplied. You look at there.
The court system you can look into, na?
They support your contention actually.
Not a computer examination. Ever any chance of traveling to?
Yes, ma'am.
Yes.
As my instructions are there.
You don't want to hear the judge also?
No.
You have to resist your temptation to argue. In American courts, they will fix the time for every case. And then after the time is over, howsoever loudly you may argue very efficiently like Balkiwala, but it will not be looked into. It goes. Same thing has happened in the examination. After the time was over, whatever you have written, that goes, because efficiency of a candidate has to be adjudged with his performance in a time-bound manner. Suppose we ask you to write an essay on the people of Orissa within 3 hours. You will write it in 3 days. What 3 hours you have written, we look into. Rest of the things will pale into insignificance. Similarly, because you are being chosen from the pool as the competitor for public service. So in a time-bound way, you have to do that way.
And actually, when you write beyond time, you must understand this. That is how I was asking you, do you understand about the computer? Read the last 5 lines, 6 lines. However, Mr. Kisku, read it slowly, then you can understand.
However, Mr. Kisku continued
little bit louder.
So that we also hear.
However, Mr. Kisku continued to answer the remaining unanswered question despite my question, and he saved the same in another file.
Stop there. So computer actually is very neutral. So they have, in fact, they know whatever you have answered within time and beyond time. Beyond time answers are not rejected as such also. They're saved also. So kindly read further.
Another file. Subsequently, the system assistant collected the files to get the printout. As the candidate had answered question number 4 and 5 beyond the stipulated time, which was saved in a separate file, I had given my remarks as the answers given beyond the time. In the stated circumstances, the answer in those sheets may not be accepted as valid answers for the purpose of evaluation.
It cannot be accepted because it is there. It was earlier done manually. You must have appeared common, public examinations like you used to appear. They will snatch away.
They used to snatch away the answer.
Stop. They say pen down. So computer has evolved it in a different realm actually. Even if you go, you can answer the entire day and know the difficulty, but the file is created separate.
Have you alleged any mala fide against this person?
Yes, my lord, because my instruction is that
computer has to allege, my lord.
I never continued after the time bound. Even if for a minute, even if I have it is my time expired of the time, I have been my signature has not been given. That you have at the time of the report, the collection of answer sheet, I have not given an opportunity that I have to know that.
Sir, it is a malpractice in examination.
No, I have never continued after the time.
So that you have to allege malafide against the computer and in fact in the system program, software program actually. This I was discussing when I was elevated with Mahapatra. Because unless we go to that extent of alleging and proving malafide against the software is selective against Mr. Kisku. That's the problem.
No,
discrimination as far as computer software is concerned, we are yet to
No, there is nothing. An unsuccessful candidate in the public examination is grieving before the writ court, contending that two of his answers have been left unevaluated, and as a consequence, he was graded below than what he was otherwise entitled to. First, next paragraph. Learned the state counsel, Mr. Panda, appearing for the respondent, opposes the opposition. Learned advocate,
you are successful candidate.
Successful candidate. 3-22.
Appearing for the official respondents, and the Shri finds appearing for the successful candidates, oppose the petition, contending that whatever is written after the specified period of examination is liable to be ignored in as much as the candidature has to be assessed on the performance done in a time-bound way. First, we agree with this. Next paragraph. The vehement submission of learned counsel appearing for the petitioner that he had in fact written the two answers within the specified period and therefore his client is entitled to have the evaluation of the same is difficult to countenance. First, it hardly needs to be stated that the examination is conducted by employing the computer services and it is not possible to allege any mala fide or ill will to such examinations or the instruments that are employed for examination. First, next paragraph. Well, we are also not in a position to.
Para 10 of my it may be. I have nullified what nullified.
Therefore, we rejected that. We have rejected that. What you have
no time has been.
We are also not impressed by the submission of the net counsel from the petitioner as to how and why his client should be singled out for unfair treatment. First, next part, in those circumstances, petition being devoid of merits is liable to be rejected, and accordingly it is, what's having been made.
So instrument and software. What software can be asked?
One sentence.
Computer, instrument and software. So.
Yes.
Item 22.
Yes, sir.
May I please? Yes, my lord, I have already filed my submissions. Dead chart and submissions I have already filed.
No, give foundation facts.
My lord, your lordship kindly see the last order dated 2/4/25. The fact of the case, my lord.
Yes.
The fact of the case, my lord, this is a case for promotion to the post of process server.
From the post of?
From the post of Daftari, in case not available, peon. From the post of
Daftari to process server.
Daftari to process server.
Do you know that
and in
great
case
advocate C.K. Daftari, the second Attorney General of the country?
Yes, yes.
Have you heard of
Daftari, C.K. Daftari. In case Daftari, they are not available, then peons, they can be considered. The rule provides.
They used to call this the Parsi.
As per rule,
without a problem, is only very clear.
As per rule, 5 years ACR to be taken into account. 5 years ACR.
5 years
service. 5 years preceding 5 years.
Immediately
preceding 5 years, that is to be taken into. And this is next, your lordship kindly.
Which rule says that?
The recruitment, the conditions of service rule, that also I have annexed.
Where is that? Which page?
And that also there, that position is admitted. What I have
not admitted. You have to tell the court it's a rule position.
The
rule cannot be proved. It has to be argued.
No, I have also enclosed the complete rules.
Kindly take us to that.
Annex 7.
Yes, Annex 7.
Annex 7.
Which rule?
Rule 15, your lordship kindly come to this rule 15.
In page number?
Page 45.
45. Scroll to 45.
Promotion to the cadet of processor.
Sub-rule?
The promotion to the post.
We are asking you,
yes,
which rule says 5 year PAS, what you call it here? ACR. To be only immediately preceding 5 year ACR to be reckoned.
No, it is the rule provides the promotion.
15, rule 15.
Rule 15.
15, sir.
Page 45.
It does not say.
Page 45.
It does not say anything about ACRs at all.
It said 5 years satisfactory service of the, in case Daftari that is not available, then they have to put in at least 5 years satisfactory service in the office peon, permanent established after adjustment.
Topic 21 regarding whether there is a statutory rule governing that they have to take into account the ACRs.
ACRs.
So that we will go to the next stage. That what they did with that.
And only 5 years
If you
records.
have to examine it, then
Only 5 years records. That it doesn't say that this is
satisfactory service.
Satisfactory service.
That should be ascertained from ACR only.
From ACR only. Suitability comes seniority.
No, you said
and then they have
immediately preceding 5 years. Where is that?
That is not
terminology.
That is not there.
That is for gazetted officers.
That is not there. Yeah.
Put in at least 5 years of satisfactory service office. It does not say it
doesn't
5 years.
It is
Suppose if you have put 10 years of service.
A class for this is a class for employees.
You are right.
So then you also kindly come to this annexer D/1. They have, this is the report. D/1 of the counter.
Your client satisfies that requirement.
This is the document. This is the
question at all. I'm asking a question to you. Question is, does your client satisfy that requirement? Requirement of 5-year clean, the satisfactory service.
I have said that. I have clean records that I have said.
Take a stand that 5 years was not satisfactory. That should be your answer.
I have
61. Page 61. Yes, and that's that much. Needs improvement, leaves headquarters without permission.
Without permission.
Slow in following instructions.
Then how can you say that satisfactory?
That my lord, that is the order, that is the noting. It is on 26/10/22.
26/10/22.
This is the reporting. The officer has reported on 26/10/22. Promotion order has been issued on 2/1/22.
2/1/22.
2/11/22.
So subsequently it is done.
6 days, 5 days after.
2/11. You said what?
2/11/22.
2/11.
But only 5 days after.
Not 2/1. 2/11. Therefore, they have taken
Was it
and that
considered? Was it not considered or your case is?
Then affidavit was directed to file. They have filed the affidavit. Your lordship kindly see this affidavit.
What they say? Where we will believe you.
My lord.
We will believe you. We will look into that afterwards. What the affidavit says?
Affidavit says, my lord, the committee further perused Gyanendra Kumar so in the garrison, but it was found performance report not so good. PO has given, he needs improvement and he headquarters with the
yes, this they have looked into. That is on 26/10/2022. And appointment is on 2/11/22. Assessment has been done on 2/11/22.
My lord, this is at least 5 years records should be considered. And this is the report, it has been given only 5 days before. And that has never been communicated to me.
No.
And I have no knowledge of this report.
No, this question is, this
is the adverse, your lordship, this is the position, my lord, any adverse, that must be communicated to me. I should know my career, since this is an adverse report against me, this should have been communicated to me at least. And nothing since last 5 years, nothing has been communicated.
How many years of service you have put in?
I have been they have considered and promoted to the post of Daftari.
Why are you not
and thereafter this.
Why can't you understand our question?
Yes, your lordship.
How many years of service you have put in?
I have already put in. Since 1986, I am there.
Yes, brother, 30 years he has served. And one single, with one stroke of pen, he writes, a magistrate. Not
I stand corrected 40 years.
40 years.
39 years.
Anyway, 39 years he has served. If it was not satisfactory, you would not have continued in service at all. You have acted upon one sporadic adverse remark Yes. And you have not communicated it. How can you deny promotion on the basis of uncommunicated adverse remarks? But 39 years he has worked.
Or Mr. Panda, anything else was there because they have no future apart from becoming Daptil.
That is the one promotion he should get.
Everything.
Which is that judgment. State of Bihar was where Apex Court said at least one promotion should be available to an employee in public service. It's not such judgment. Yes. Correct. No, this has to be allowed.
There should not be any stagnant.
Person works for for 39 years, and you say his services are not satisfied.
No post yet. I mean, retirement vacancy or promotional vacancies.
That is there.
That should be the direct against that post.
You promote him. Otherwise, he will go with heavy heart from when he quits the service.
Yes, 4 years of service.
You promote him. It's a case for promotion. Otherwise, you would not have continued him for 4 decades. Who will continue for 4 decades? One single sentence by the magistrate.
Not
and he had not been intimate.
It was true also, but that doesn't make a difference.
But it makes something. One needs improve. He needs improvement. Oscar Wilde said there is scope for improvement even in heaven. Everybody needs improvement.
He should have been intimated about. He should have been intimated about his
At least he should have been told, you brother, you need improvement. As we are telling the bar.
And leaving headquarters has to be a matter of record. He left headquarters has to be a matter of record that he was intimated so and so date that he left headquarters. But anyway, that's too proximate, not communicating.
Not communicating. Notes. Petition is allowed on the following grounds. Number 1. Firstly, we agree with the submission of the counsel appearing for the petitioner that uncommunicated adverse ECRs cannot be made the basis for denying career progression. First. Secondly, the petitioner before us is not just a fresher in the service, but has put in 39 years of spotless service.
He has joined on 22/11/86.
Having joined the services on 29/11/1986. 29/11/1986. First off, it would shake the conscience of any reasonable mind that a person who has been continued in service for nearly 4 decades should be told that his services are not satisfied. First off. Next point. One sporadic ACR, assuming that it was communicated, cannot be sole basis for denying career progression when nearly 4 decade service, spotless service has been rendered. First off, it was Shakespeare who said, one swallow makes not the summer. First, that applies to this case in all force. First, in the above circumstances, consider and in the above circumstances, this writ petition succeeds. A writ of mandamus issues to the respondents to consider and grant one promotion from the post of peon to the post of Daftari.
Daftari to process server.
From the post of Daftari to the process server. Within a period of 8 weeks. First, delay shall be viewed very seriously. Now no costs. Take this one. Now no costs. One more point. The Apex Court in, which is that decision where so Apex Court said one promotion has to be granted.
Bihar judgment. That judgment.
You supply that citation. Apex Court. in a Bihar case said that at least one promotional avenue should avail in public service so that there shall be no stagnation and the employee goes home back with heartburn.
But our one ground was there, my lord, because the that count we have taken in our counter, the affidavit.
Yet
that communication of adverse remark is not stipulated in the rule, consent rule.
No, Apex Court said contrary. If the rules say
it has to be read into.
That natural justice principle, you have seen that famous judgment, Mohinder Singh Gill versus Union, the Chief Election Commission, 78, Supreme Court 891. The rules of natural justice should be read into every provision of every statute and every rule, unless otherwise indicated. One sentence you have to make that one. Now, Mr. Panda appearing for the correct. Also, two judgments have to.
Communication that is
AR 1976 Supreme Court. One SCC, not here. SCC we can read.
One SCC 37.
Check the motion. Just to get Mr. Panda with just one line to write. Mr. Panda appearing for the respondent eventually argues that the extant rules do not provide for communicating the ACR, and therefore non-communication cannot be weighed in favor of the petitioner employee. First off, we do not subscribe to that way. First off, the Apex Court in Mohinder Singh Gill versus Chief Election Commissioner, AR 1978, Supreme Court 851. So, is high judge bench.
Very good has to be communicated. It is not a
conjugal judgment. Said that principles of natural justice have to be read into statutory instruments unless the contrary is provided for. First off, no such contrary is pointed out to us. First off. This apart, in Abhijit Ghosh Dastida versus Swain. So, Justice Kaju's judgment, just look into one. Where is our researcher? Where are you? Yeah.
Devinder
has observed. Even when the concerned entry does not have elements of adverse elements, even those have to be communicated to the employee so that he would make value additions. That's it. 2009, 16 SCC, 146.
Last judgment. This is the last judgment. 2013 is the last judgment.
One judgment. Article 141 says, law declared by the Apex Court. It does not say law repeatedly declared by the Apex Court. One decision of highest court will make a law. Anyway, structure that change. Now no court. Suppose because we have written now no courts, because if he comes again before the court, cost will be imposed. That's the meaning. Yes.
Item 23.
22 is over now. Yes. Yes, Mr. Panda.
Yes, sir.
Item 23.
Well, it's a state appeal. Lordship may kindly have a glance to the impugned order at Annexure 1 at page 16.
Notice has to go. Issue the emergent note. Any
at the first date, on the first date, no opportunity, that's one. State have allowed the writ petition.
When notice was issued,
notice was never issued, my lord. Notice was never issued in the writ petition.
Did you seek time?
No. Lordship may see the page 16, Annexure 1. First order, right? Order number 1, my lord, 17/4/2023. No observation, the notice was issued, any opportunity was given to file counter. Straight away, my lord, the judgment comes and, my lord, the writ petition is allowed.
Same day?
Same day, my lord. And the judgment is contrary to law, declared by the Honorable Apex Court.
What do you say, brother?
This is matter has been, my learned friend has said half truth. This is remanded from the Honorable, they have gone to the Honorable Supreme Court, and the Honorable Supreme Court has remanded the matter for fresh hearing.
This matter?
Of this, yes. That is there, that is why it has been.
After remand by Supreme Court, still
now it is
upon first date.
No. This after the given. Honorable Supreme Court says that the writ appeal is to be hard on merit. Delay has been.
I'm not a writ petition.
This, my lord, is the writ petition was disposed of what the order he says. Against that, writ appeal was filed. Writ appeal was allowed. That means the judgment was affirmed here.
Writ appeal was dismissed.
This was dismissed for delay on.
No, yes, sorry. Then they went to Supreme Court because writ appeal was disposed of in 2 counts, both on merit and as well as limitation. So they went up to Honorable Supreme Court, and Honorable Supreme Court remanded the matter on 12/2/25.
What is the order of remand?
Yes, that is there, my lord.
No, his grievance.
Yes, this is the order.
His grievance is.
No, that Honorable Supreme Court has taken note of, and it was directed to be heard, and this Honorable bench also last occasion.
On 18/6 you have to hear now.
No, 18/6 it was there, my lord, it was heard.
Lordship may see the Honorable Supreme Court's order, where only delay ground has been considered, not any point, any other point. Only
Ustad Malik.
Yes. I have given that order.
This asked to that 500 cases.
Flag X, it is available in Flag X.
And last date it was heard. And a point of law was raised with regard to the pendency of last date, my lord will recollect, because that is not reflected in the order sheet. Whether the charge sheet was filed in that criminal case, vigilance case or not, that was, I have filed the document along with the affidavit that till that particular date, I have given the certificate copy. The order.
He is now saying, bringing to the notice that order in writ petition, because it has to, appeal has to be reheard again.
Yes.
So he's saying about the order in the writ petition actually.
Yes, same thing.
So you are supporting order of writ petition. Kindly place it.
Yes, that I'm saying.
17/4.
Only, my lord, only point to be resolved by this Honorable Court is as to whether, keeping in the mind in the ground he has taken in the writ appeal, as to whether pendency of a
after remand by the Supreme Court to be decided on merit.
Writ appeal is to be
so you are supporting or opposing the writ petition.
No, I am supporting the judgment.
Please place it.
Yes, my lord.
So give the reasons. Where it gives the reasons.
He was in a sealed cover.
The court has said, court has said that was to open.
Court has said to open it and give the promotion during pendency of the DP and during pendency of the criminal proceeding. The DP, my lord. This is departmental proceeding. Departmental proceeding.
You will keep it in sealed cover. You will keep it in sealed cover, saying that he is otherwise entitled to promotion, but criminal case is pending or disciplinary proceeding is pending. Is it not?
Yes.
Or you did not consider only?
No, we considered.
You considered. Considered and it was positive.
No.
Otherwise it will not go to the sealed cover at all.
May I submit?
My lord.
Oh, yes.
For last 2 paras, my lord.
Now we are asking you, Mr. Panda.
My lord.
Whether this case was recommended for promotion.
It was in sealed cover. No.
In sealed cover is true. That is one famous book by Gaurav Bhatia. Unsealed covers. Famous book on many judgments he has referred. Very beautifully he has written Bhatia's book. Yeah. Now we are asking you, What was the recommendation?
And the other difficulty, Mr. Das, is para 7, the court has referred to the judgments. In how many cases criminal cases are pending? Look at para 7 of the judgment of the, because one grievance is raising that he is not given an opportunity. This is the first state, order number 1/17/4/23.
Yes.
The reference is made to the Supreme Court decisions that he should be given, the seal cover should be opened and he should be given promotion. So in how many cases, those cases are relating to criminal matter? Pending criminal cases.
What is the criminal matter against you?
Yes, that is the issue, my lord. That is the issue. Against me, my lord, that if I will permit me, I will also submit now. There is, as on date, I have given the certified copy, the so-called vigilance case, no charge sheet filed, no cognizance taken. So therefore, in view of the Janaki Raman judgment, my lord, Honorable Supreme Court has held, unless a person is charge sheeted or cognizance is taken, he cannot be said to be an accused in that particular criminal case. So far the disciplinary proceeding is concerned, my lord, the law is otherwise. The date DP instituted, I am under the proceeding.
No,
and now the government has just
memo to be.
Yes, that is the proceeding has been served on me. That is the proceeding. But thereafter, government has issued a circular on 76/21. In this, our state government has issued a circular. If a proceeding, department proceeding, could not be disposed of within 2 years, and in the meantime DPC is conducted, he should be given a promotion. It should be considered promotion. So therefore, on count of DP, there is no problem because it is beyond 2 years. I can only the ground they have taken in this particular case appeal. The ground is the pendency of the vigilance case. The vigilance case is my responsible submission. I have given with the affidavit.
Mr. Das, unless we allow them to file counter as said by the Supreme Court, we will be doing the same mistake.
No counter. It is the writ appeal itself. It is the ground, my lord. The court has honorable Supreme Court may take. So can you? I have only one copy. Shall I read that? My lord, may I request my lord to give me that? I have only one copy. Just read out. The Supreme Court order I have handed
expedition.
Yes, only one copy. Sorry, my lord. Sorry, my lord. I could not.
It is there.
Yes, it is there because I have.
So you don't have to give it to us.
No, because my lord wanted just.
So my lord asked that
both parties should cooperate in disposal of the matter. That
yes,
is what the apex court has.
Yes, ma'am. My responsible submission is now the grounds in the writ appeal. To me, my lord, is the ground. Whatever the counter they could have filed in the writ petition.
One second.
My lord.
Wait. Mr. Panda, suppose if we send the matter back to the learned single judge, how that would come to your aid? What is your stand here? There you should have been given opportunity of hearing. It's true. We are giving that opportunity of hearing. What is that? On what basis you can deny promotion to him? Only 3 points, regardless of lengthy argument. If you have followed the sealed cover, first contention is there was no basis for going for the sealed cover. Is his submission. He says, in view of Janaki Ram, either in the case of criminal case, charge sheet should have been charged. The charges should be framed, not even filing charge sheet.
That was not there.
That is not there. That 179 report has to be done that one.
That is an admitted position.
Admitted position. No charge memo is issued in respect of disciplinary inquiry.
No, charge memo was submitted 2 years back. 2 years back.
2 years.
So that I'm taking help of.
Then circular comes to his aid. If matter is pending beyond 2 years, you can't deny promotion at all. That circular is your circular.
Because that's the policy of the government.
That's the policy of the government.
Which circular?
That has not been, they have also not taken that down.
No.
Yes.
Your rate petition.
Yes.
Yes, 31.
Yes.
31 in your.
17/6/2021.
So which paragraph? 76? In page 31 of your rate petition. And
that I'm not holding that.
Where it deals with criminal cases?
That is not with the criminal case. That is only with regard to the DP. That circular. That my lord got
case is a pending criminal case?
No, in this case, they are taking the plea of only pendency of the criminal case.
EC Act?
No.
Yes, in the vigilance case, no DP. That circular is coming on the. Circular is with regard to the DP. Circular I have filed one. Yes. In the report.
Then that is not to be looked into.
Yes.
So which is the circular in criminal cases?
It is
No circular.
no such circular.
No circular. But my case is, my lord, because they have also relied upon a judgment of this honorable court, a coordinate bench. There, my lord, the criminal cases were pending against those persons. Accordingly, the writ appeals were allowed, setting aside the identical orders of the honorable single judge.
1 second. Why my brother is asking that is, the circular is confined to disciplinary proceedings.
Correct, man.
You cannot take advantage, you cannot draw milk from the circular because yours is not a case of disciplinary proceeding, but it's a case under the PC Act.
Yes.
What is the stage of the PC Act now?
Yes, that is no charge sheet. Nothing has been done. Only
we have to.
I have given the certificate copy in the last occasion. That was the issue. They have filed an evidence, sir.
We will
Please,
apply your
please,
lordship by filing an
allow me to speak.
grant 2 weeks.
No, that is the problem. Last week, the last date, that the same thing happened. I have filed that.
Suppose you see,
I have given the certificate.
so that's he's in a way supporting you. Suppose he concedes that nothing has happened as you have said. So why you are disbelieving him?
No, why? I have filed the certificate copy
please be patient.
before this honorable court. Where is the reason?
Please be patient that.
No, I have. My lord, kindly see, this is a case of 2021. My client is.
No, I don't understand 2020.
No, I have given the certificate copy. Can he go beyond the certificate copy? That is my submission, my lord.
Cannot he wants to obtain instruction on that only?
Last occasion I have supplied to him. No. What? No. Nahi, that is something different. I have given him.
Sir, what is the difficulty for him to take instruction?
No, I was that way. I am impressing upon the court. My lord, I am impressing on the court. The last occasion I have given that certificate copy to my lord.
You are impressing upon the court. Not to see the latest status.
The latest I have given it. So because it is not the question of latest status. It is the question on the date of DPC whether there was a criminal case.
The problem is that you are not listening.
No, I am after listening, after hearing my lord, I am giving an answer.
I have to keep
the
quiet.
problem is
Then I have to keep quiet. I have not said anything regarding what you are saying. Did I say that you did not submit anything?
you are in the receiving end, sir. I cannot answer it.
You are the receiving end for what?
Sir, please. Don't parallel about this issue, sir. Kindly ask me the questions. I will answer it.
No, I never asked any question.
You do one thing. Let's push this matter before some other court. After taking appropriate direction at the hands of Honorable the Supreme Chief Justice. Since learned counsel for the petitioner or opponent?
The respondent.
Respondent submits that he is at the receiving end of this court.
No, this is. Let it go. With the due respect, my lord. With the due respect, my lord. I never mean so. Only thing, my lord, I want to complete the sentence.
Everybody.
Yes.
Thousands of people are looking there.
I am not saying so. I never mean so, I said. I never mean so.
Why can't you bring someone to control you?
It's not.
That's what. You cannot control yourself now. Therefore, we are telling you. When a lawyer says that he is at receiving end, we are not disputing that now. Therefore, we are saying, we are requesting Honorable Chief Justice to send this case to other bench of your choice.
No, not my choice. Honorable Chief Justice will decide. Honorable Chief Justice will decide.
That's what.
Not my choice.
That's what. Push this case before whatever. Because we don't want to give an impression that we are denying relief, etc. to others. Whenever case is made out, we give relief. Whenever case is not made out, we can't give like freebie as the governments will do at the political levels. We cannot do that. Anyway, it is better that Honorable at the hands of Honorable the Chief Justice, since learned counsel representing the respondent employee says that he is at the receiving end of this court. First off, we feel bad that that impression is gathered by the learned counsel.
Item 24.
24, my lord. 24 on behalf of SP Das can taken on next to my lord.
Yes, madam.
My lordship,
Sadrusham Pavitra There is nothing as sacred as knowledge.
My lord, this is great appeal.
Many discussions we made so that youngsters will be benefited. It's not for seniors at all. All seniors are very highly knowledgeable, very, very efficient. We agree with them. Yes. Item 30.
My lord, this is state appeal where a contractual employee whose appointment, service, everything is totally guided by the contract. And contract is express contract. And that guidelines.
Statutory contract?
No, we have formulated
no rules at all.
No rules. Only contract and guidelines have been formed.
Guidelines have
mission that rural mission health. In that, my lord, when it is specifically communicated to the accountant cum data entry operator, he was accountant data entry operator, that Annexure 10 of the read petition at
foundational. When did he get entry to the service?
My lord,
contract entry. Contract is dated?
My lord, I'm just some dates are there, my lord.
Can you give, sir?
Yes. Annexure 2, that is on 1912.
No, we are not. Give the date.
1912-2012.
I'm just 5/1/2015.
5/1.
Initial contract period.
Appointment. The initial appointment Annexure 2, that is 1912-2012. I was appointed.
1912-2012. Then it is renewed.
It is renewed extended.
From to time.
Time to extended.
And your prayer for regularization is allowed by the learned single judge.
Actually, not regularization, but I was terminated.
You were terminated. Therefore, reinstatement is granted.
Reinstatement is there. Without following the principle of natural justice and without resorting that the guidelines, now abruptly I was terminated.
But you are a contract employee.
Yeah, I am a contractual employee. But the ideology renewed by showing that my performance is good. And just after some days, as because there is tussle between me and some officers, now at the instance of officers, my service was terminated without following the rules, without following any principle of natural justice.
1 second. If it is contractual, whether principles of natural justice.
Yes, that hasn't dealt with. I'll satisfy lordships. That hasn't dealt with by the honorable single judge in a number of decisions, not one or two. Series of decisions that is reflected in the judgments. If lordship go through the judgment, I think everything is clear.
Let us see. I will come back to you.
All right.
Yes, Mr. Panda.
My lord, the improved judgment takes care of the learning page 41, my lord. The appointment letter, initial appointment letter 1912-2012 is extracted in extenso.
Page number 12.
Page number 41, my lord.
Of your paper book? E-book?
Yes. Continuous page 41. 41 continuous page. Page 23 of the judgment.
Page 23 or
23 of the impugned judgment.
Inner page.
Inner page.
Go to judgment now.
Yes, 23. Yes, page 23. Para 18, like a thing.
Para 18, Panda, you are referring to retapil.
Retapil continuous page 41.
Running page 41.
Running page 41.
What they have done, they are struggling so.
Paragraph 18 of the judgment.
Uh, 1912-2012 is entry.
Entry.
And termination is dated?
Termination date will not.
Any order was made or only orally said from tomorrow?
Order was passed.
Order was passed.
That is Annexure 11.
Not renewed. Non-renewal of contract.
Yes.
On which date they said will not renew?
That I was drawing your lordship's attention.
That is on 17/2/2016. 17/2/2016. Annexure 12.
17 or 27.
Sorry, 27, right. 27/2, yes, 27.
Before that, your lordship may see Annexure 10 at page 37. 23/2/2026. 16. 23/2/2016. Warning to improve performance.
Within 4 days improvement.
My lord.
23 you asked him to improve.
That is the only.
By 27 you have removed.
Removed.
It is like asking the daughter-in-law to become pregnant within 1 month and you also.
That is the cross below. I bow down to that. I bow down. But we have categorically stipulated in the order. Last, the second paragraph. Therefore, you are warned and given opportunity to improve your performance by 3/3/2016 as your contract period is extended up to 3/3/2016. If you fail to improve, no further. So it was categorically stipulated. Oh, yes.
Appears to be something wrong with your government. Which officer? Some reasonable time should be given for improvement also. Improvement does not happen within one day.
It could have been given earlier.
After all, he is not a surgeon.
No.
Is he a surgeon?
I completely bow down. To this aspect, my lord. But the fact is that
But he continued his service up to March 23.
No. 3/3/2016.
He continued till 2016.
3/3/2016.
Para 18 it's 3rd March 23.
3rd March 23.
Para 18.
May not be this. Any interim order was there? It cannot be 23 because repetition is of which year?
No, that is, I think that
2016. It cannot be 23.
That is 16.
That is 16.
Was he continued in service?
No.
He was terminated.
Terminated on that date 3/3/2023 or 2016.
You want to build your case on the premise. It is not a case of termination. It is a case of non-renewal of.
Exactly.
That is 2018-3.
Exactly.
Yogesh Mahajan's case.
Yes.
In that level.
Exactly.
But it does not appear to be that way. If I will tell you why. If you ask him to improve on 23/2/2016.
Yes, madam.
How is that you will ask him to? You will say that you will not renew the contract because he has not improved on 27/2/2016.
Because, my lord, on the very same letter stipulates the last date of contract, my lord.
You would not have said it. After all, common sense. If within 3 days he is going out because contract is expiring, the term is coming to an end. You would not have asked him to.
You would not have given that warning or that reprimand that you should have.
Number one.
Yes.
Number two, having extracted the service for almost 4 years.
Yes, madam.
If you ask him to go in the middle, where he should go? He has to jump into Mahanadi. Or he has to become a criminal on the street. Where you will be a victim, I also will be, perhaps. If I get down from my car and my security do not surround me. No. The elements of justice are absent in the government's order. You are not East India Company. You can't say so to someone, I want today, tomorrow I will not take you. Those have
the sole ground of challenge, my lord, and submission before your lordship, that contract doesn't permit beyond this period. It was stipulated. The date is.
But you continue.
No, we continued. That continuation also is stipulated by the date.
Correct. But every time you will stipulate, every time you will overcome that. That goes against.
And that depends upon the performance. That's the guidelines. Guidelines is very clear on that.
You have, you caught that branch where you yourself you are standing because you on 3 days you say that you improved, then you terminate.
You wanted to say go.
What is your best point in that because it's allegation of discrimination or irrationality?
Irrationality.
So is it that the such type of contracts are never renewed for any other employee?
Did you engage others in his place?
Accountant?
That's not your case.
No.
What was your job?
My job is clerk, accountant.
Accountant.
In the CHC.
Which accounts he has not done properly? For an accountant, if you ask him to improve, what he should do? Which accounts he have not properly maintained?
The performance appraisal report says that performance.
Correct. There should be, it should be someone, you may not tell it to him, but tell it to us. For which period, which account you found defective, which account he did not do.
Performance appraisal committee has not dealt with in a transparent manner.
Learned judge has done properly. Right. This intra-court appeal seeks to call in question a learned single judge's order dated, rendered in WP, respondent WP. Please be seated. Vasantu. In respondent employees WP number so and so. Person. In the said petition, respondent employee had sought for setting aside of his termination and of consequent reinstatement in service with all consequential benefits. First off. Next paragraph. Learned State Counsel, Mr. Panda, in his usual style, usual vehemence, submitted that the case of the respondent employee was one of the realm of contract as distinguished from status in the light of, which is that judgment, in the light of Tulsi Ram Patel versus Union of India. And therefore, the learned single judge grossly erred in treating the case on a contra premise, inarticulate, and thus there is a lacuna in the impugned order. First of all, he further submits that the official respondents had issued to the employee in question a notice dated 23/2/2016 for improving himself in the occupation, and he did not improve, and therefore his contract came to be not renewed with effect from 27/2/2016. First time.
3/3/2016. 3/3/2016.
3/3/2016.
Order is 27/2/2016 with effect from.
While order dated 27/2/2016 with effect from 3/3/2016. First off, the process into service apex court decision in Yogesh Mahajan. Yogesh Mahajan, you only. Mr. Panda.
Yogesh Mahajan,
if it is contractual, it cannot no question of
Yogesh Mahajan, yes, responded Mr. Mahapatra.
Was against? Anyway, later. Next paragraph. Learned counsel representing the respondent employee per contra submits that the case is not as simple as has been sought to be made out by the learned state counsel. Semicolon. The respondent gained entry to the service with effect from 19/12/2012 as an accountant, and he had been serving department concerned with all zeal and just, with no spotless, with the spotless records. First one. Further, he submits that notice to improve was issued on 23/2/2015. And on 27/2/2016, he was asked to go home, saying that there was no noticeable improvement in the performance. Therefore, it is order is punitive and stigmatic and lacks bona fide. First of all, he also submits that gone are the days of East India Company, and the state has to state and its functionaries have to conduct themselves as model employer in the light of Bhupendranath Hazarika versus state of Assam.
2013 Supreme.
2013, so and so. And first, lastly, he contends that the impugned order of the learned single judge, being pregnant with the elements of justice, does not merit interference at the hands of this court. First. Next, having heard the learned counsel for the parties and having perused the appeal papers, we are broadly in agreement with the submission made on behalf of the respondent employee. And reasons for this are not far to seek. First off, the entry of the respondent employee into service with effect from 19/12/2012 till 3/3/2016, 12, and that he served the institution till 3/3/2016 are not in dispute. First up. It is not a pure case of non-renewal of contract of employment, in as much as the employee was given a notice dated 23/2/2016 to improve, and the authority who had issued the notice wanted that improvement in hours. First time, in any human institution, that does not happen. First time. Improvement, there is scope for improvement even in heaven is true. First off, however, for that, a reasonable space has to be given. First off, the notice period, the period of appraisal, very strangely, is too short to be little. That is between 23 to 2016 and 27 to 2016, the employee having been sent home with effect from 3/3/2016. First off, a state cannot be that arbitrary. First off, the apex court in E.P. Royappa versus State of Tamil Nadu, 1974 Supreme Court Triple 5 said, all actions of the state have to be just and reasonable. And admittedly, appellants are Article 12 entities under the Constitution, answering the description of state. First. Next paragraph. We do not agree with the learned State Council that it is a simple case of non-renewal of contract of employment, contract for employment. They are above us. For employment. In as much as yearly his services have been, employee services have been continued, notwithstanding the discretion retained by the respondents to make him quit at the end of the year. First time. Renewal of contract from time to time, year after year, goes to show that his services are required in the organization. First off, it is not the case of the appellants that the services of the respondent employee are dispensed with because they are no longer required. They were no longer required. First off, we may assume that in the state cannot replace one temporary or contractual employee by another set of contractual employees unless the rules otherwise provide for. First off, in the above circumstances, this appeal being unworthy of merits is liable to be and accordingly dismissed. Costs having been made easy. How much time was granted to implement the order of the single judge? Within what time you are going to? Otherwise, one more contempt again. Yes, still, when will you implement the order of the learned single judge?
4 weeks.
Within? We'll give you 6 weeks.
6 weeks.
The appellant shall implement the order of the learned single judge within an outer limit of 6 weeks and report to the Registrar General of this court within in the 7th week. Okay. Yes.
The petitioner before your lordship,
One minute. I have filed a counter affidavit yesterday only. Probably it has not come on record.
My Lord and friend. I have got the copy. My senior has given me the copy. My Lord, hard copy is there.
You don't have copy. Section. Now it has to.
It's all right. My Lord, the petitioner is an institution who wants to shift the institution to some other place.
But this argued before us for some
Yes,
time.
your Lordship was kind enough to issue notice and directed them to file a counter. Just to refresh my memory in placing my case properly.
Subsequently, that circular or notification came into force. Last time.
So I am whether now the point is whether I am governed by the previous circular once the transfer or the changing has been made, or I will be governed by the new circular. This is the only point.
Simple.
My Lord, the
circular does not say.
But the circular to which they are referring to is just a clarification. The original circular, original guideline I have annexed. Annexure 1, you will also kindly see. There was a restriction that there cannot be transfer beyond the block.
Beyond the block transfer is not possible.
It's not possible.
You have not permitted anybody that way.
My Lord, my humble submission is it has been permitted under circumstances like
covered by provisions.
My Lord, there are certain provisions. I have also annexed that guideline.
Here actually the state has already permitted.
State has not
basing on your circular.
State has given NOC. There are
permitted or not. Obviously, NOC is a permission or not?
Yes, my Lord. No. But ultimate.
But effective order will be passed by you.
Yes.
Relying on that circular.
Yes.
So your circular is dated.
Your Lordship kindly turn to
date. Deadline 5/11/21. Is it a different circular?
My Lord,
so that now he has to answer that.
Affiliation norms, your Lordship kindly say that is the basis, foundation.
It is little bit nuanced. Whether Mr. Bose is relying the same circular, both of you are relying, or
yes, we are all relying both. There is no dispute on. There is no dispute with regard to the circular.
No. First circular, you said something else.
My Lord, your Lordship kindly turn to my
page 13.
My Lord,
affiliation norms for
affiliation
year 2018.
Yes, my Lord. Page 14, your Lordship may see towards the bottom. Instruction for 3.5. If any existing institute relocate to a new location without following latest sensitive norms without...
No, that is not applicable. That is not their case.
Yes, my Lord. While relocating the institute to a new location, institute shall ensure all trainees enroll, complete the training duration, and no fresh admission are admitted. That is not their case, my Lord.
That is not applicable.
My Lord, your Lordship, clause 2, your Lordship, kindly see.
Now, whoever is undergoing training, that training period should be complete.
They have to complete that period there in the original place.
They are agreeable with that.
But they have not done that, my Lord. They are going there admitting.
Now we will make it clear that this condition 2 should be complied with. They are agreeable.
But they have admitted students and they are continuing. They are seeking for transfer from one district to another, my Lord.
Another.
The question here is, my Lord, mobility of the students. Students, those
who will be put to injustice, hardship.
Yes, my Lord. Those who have taken
students, suppose that's but you are saying that this prohibits, because your contention you are elevating to the 3.5 to the level that they cannot do it.
My Lord, they cannot.
So if you say they cannot do it, it's not a question of whether the students can go or not. If you say they are permitted, then the conditions will apply. That in these conditions will allow you to see.
Likely hardship to the students who have already. That for that, what is his assurance? You have to ask it. For that, he is not putting it properly, and even people not properly.
The other part, if it prohibits, they cannot.
It provides for subject to condition.
If it prohibits, then they cannot.
But apart from that, my Lord, their application was also rejected.
No, first point we are getting. So what are you going to do to the children?
My Lord, we will comply that in strict terms.
How? What? Compliance means what?
My Lord, they are saying that while relocating the institute to a new location, institute shall ensure all trainees enroll, complete their training duration, and no fresh admissions are admitted.
Because?
It will affect the student. Absolutely, man. We will strictly comply to that terms.
Means what?
We will complete the training. We have completed the training. We have given a report that we have completed the training.
And you have not made admissions.
No, that
you have made admission.
No, admissions will end on 15. On my request, your Lordship posted this matter to 9. saying that
admission.
yes, or else my lord was posting to 23rd.
They are saying they will comply with conditions 2 and 3, both.
My lord, your lordship may see, I have
Perhaps what he's saying that
yes, my lord.
You are prohibiting admissions at a new location or the older location?
At the older location, my lord. At the older location, they have to complete the.
Then it's a chicken egg problem. So they cannot make any admission this year.
But for that, we can do one thing. I understood what you said actually. The chicken egg problem only. It is like vicious circle. Years.
It is for 2 years.
2 years.
2 years.
No new admission is made as an.
My lord, they have not opened the portal. I cannot admit.
No.
I cannot admit.
No, my lord.
Admissions are
That's
made.
not correct, my lord. They
he's
have opened the
saying
portal. It has been rejected on several grounds, not only on this ground. They are that.
He's saying that portal is not open.
He may be wrong in saying so, but have you allowed admissions? That is, he says that you have not allowed.
We have not allowed. They have
That's
given
exactly what
admission.
he's saying.
But they are going on giving admission, and for the batch 2022-23, they have given admission. That they have also.
No, that they will complete. They have to give that for the. They can't keep the running an institution is not a child's play.
My lord.
It requires tremendous expenditure, expertise, administration, infrastructure. You can't ask them to keep the institution locked with all windows, doors being closed. That cannot be. Now, with the effect from which date you want to shift?
But once they allow, we will make the infrastructure and shift. Infrastructure is half ready. I will complete the process which the students have been admitted.
Fixes the last date for admission.
My lord, it is fixed by them.
Them only.
Them only.
Not you.
No, we cannot do. My lord, nowadays, my lord, everything is on the web portal. Unless they open the web portal,
no admission.
No, we cannot admit. Our institution will not be listed in the web portal.
We'll call this matter tomorrow. You file affidavit that you are going to comply with instructions in 3.5.
My lord, your lordship may note my.
No, not. File that affidavit.
My lord, can it be day after tomorrow?
All right. Yeah.
My lord, it is in your interest.
Yes, ma'am.
It is as early as you can.
Yes, ma'am.
How many in the intake capacity is what?
My lord, that I have not. I'll provide in the affidavit. All details.
But Mr. Misra, you are saying about 23. That you could not have refused, and they will complete in 25 as per 3.5. Then only they can shift.
Then only they can make an application that will be
very clear in your instructions also.
My lord.
I mean, inconsistent and also loosely worded instruction will definitely
no, my lord,
to the benefit of lawyers.
No, my humble submission is, my lord, they have to make an application.
No, be strict and make it workable.
My lord.
They have made application, your NOC has been given, I have to, now you have rejected.
We have rejected, my lord.
On what ground?
On various grounds.
No, various.
This is one of the grounds that they.
How many grounds? How many grounds?
My lord, they have annexed the document. Annexure 6 is the. They have annexed it.
Annexure 6, we have given the reasons. Annexure 7, if your lordship may kindly see, in reply to Annexure 6, Annexure 7 at page 25, I have given that I have produced the document that I have complied with all the conditions.
Mr. Bose, it will be in your interest. You elaborately deal in your affidavit regarding the compliance.
Yes.
And so that you hand over me a copy so that then we can take a step. And you have to make it early.
Because the deadline is coming.
Yes.
Or day after tomorrow. It's the request of Mr. Bose.
All the matters will be again executed. If you want any adjournment, then the
item 44 is the interim order your lordship has passed till today.
Interim order to cut. No, whenever interim order for there, you cut.
Item 45 or twice are not reached. So.
Today also will not reach now.
Yes, so
distribute those cases.
45 is matter of 2024. It will always be at the bottom.
Already elsewhere are.
Item 42, I am asking for the appeal public to We need 2 weeks time to make counter.
So adjournments where you want, you question. He'll give you a date.
They are required to file counter LRC.
Yes, the party to call after 3 weeks at the request of respondent. 3 weeks. So 2 weeks not possible.
The job in stake LRC. The matter left to
Let us see.